Okay. Good morning, co-banker George. Thank you for coming to this legal seminar. And today we are so honored to have our corporate counsel, Brian Smith, to come to talk to us about the risk management and also how to navigate the latest RPA. Brian Smith is associated with Sams, Alec, and Lancor, pretty sizable law firm in the Woodland Hills. And he has been a litigation lawyer for over 20 years, specializing in real estate. And he is also our exclusive E&O attorney, but he also takes private cases. So if you have any question regarding real estate, you're welcome to consult him. He's a very amicable guy, and you call him, and yeah, I'm sure that you won't be disappointed. And even I and myself will call him all the time and to brush up my real estate knowledge. So Brian is no stranger to CVGR. He comes to talk to us at least once a year for the past 5 years, sometimes twice or three times. So his seminars are very well received, always very well received, and today is no exception. So without further ado, let's welcome Brian. Go ahead, Brian.
Okay, thanks so much, Peter. I'm happy to be here with you all. And yeah, I help out Peter with the legal situations that come up with real estate. And I also, if there is a claim against the company and one of you folks is the agent, I'm the attorney who comes in through the insurance company to defend the case. And I got some things to talk about with you today. The first two things I want to talk about really haven't talked about before, but the first one is, the recent, tragic situation with the fires in Los Angeles County. What effect may that have upon you as real estate agents? Are there any tips I can give you to kind of, do transactions smoothly and stay out of legal issues if there's something that comes up, related to a property that had been impacted by the recent fires? First of all, my heart goes out to everybody who was impacted by the fires, and especially you folks. So I hope everybody made it through that time as well as they possibly could. I had to pack up my house and put it in the car, but I wasn't under the mandatory evacuation order, thankfully. So, just looking at being an attorney who defends real estate agents, watches the real estate market, and seeing, the events, watching the news since January. What are the things that have come to my mind for real estate agents to be aware of? As they may be, not now, but I think, at some point off, if it's a year or 2 years, be getting involved in transactions that are in areas impacted by the fires or have some relationship to the fires. So, my observations on this are, and you can see the news, see LA County website, LA City website. There are, government relief programs, government assistance, we can call them. There will also be relaxing of permitting requirements for rebuilding, possibly. And, so what if you are, say a year from now, you are representing, um, say a buyer, maybe it's a developer, someone who likes to build, and they're, they want to buy, um, a property where, say half the house was burned down, and the seller has just decided they don't want to or they can't rebuild. I hope the folks who are impacted are able to rebuild, but let's assume for a learning purpose that you are contacted by someone who wants to buy a property that has been, greatly impacted, perhaps destroyed by a fire. And then, the buyer says to you, well, is there a grant? Is there government assistance that I can get to to build on this property because I'm buying this land and it's in an area where it's to the public benefit to rebuild. We want to rebuild Palisades. We want to rebuild Altadena. So, the buyer asks you, well, will the city give me a grant to rebuild here? I think your answer should be, something to the effect of, I know there's some new city programs. Here's a link to the city's website. I think you should take a look at it. I say that as opposed to you saying, yes, the city has a grant that will apply here. This will definitely help you with rebuilding. So you are someone who refers people to sources of information, refers people to resources. So it's, check out recovery.lacounty.gov. Check out the City of Los Angeles emergency.lacity.gov. There may be relief programs that apply and help you rebuild. Here's a link to the City of LA's website. So you are passing along information, helpful information, but you're not actually giving advice about the government assistance that is available. And the idea there is really, as a real estate agent, you're not a land use consultant or an architect who advises on if the city or the county is expediting a permit approval process. I mean, I think they will be, but let's say that you tell a buyer, yes, the city is expediting the permit approval process. I think you'll have it in 2 months rather than the usual 5 months. The the buyer acquires the property. They have at escrow, they actually sign a contract with an architect, they hire a contractor, maybe they take out a construction loan, and then it turns out that the government agency with authority over that property actually takes a year to go through the permitting process. During that time, your buyer has made some payments to the contractor. The construction loan, those have strict timelines and they have interest, they have penalties. So kind of in reliance on this comment that the city is going to do everything quicker, your buyer has purchased the property, entered into a contract with an architect, got a construction contract with a lender, and then it turns out that it was a more complicated process. We don't want that to come back to you where your client says, well, you told me the city would give me this permit in 2 months and it was actually longer. So the better way of handling this is to say, I believe there are some new programs that the city is offering. Take a look at their website. Maybe you have a buyer who really wants you to get involved and you want to be helpful. That's natural. We all want to help our clients. So they say, well, would you review the website and would you tell me what it says? In that situation, what I would do is say, hey, if you like, I can come over to your house or I can come over to your office. We can take a look at the LA County website together. And then we can talk about it. We can review it together, kind of like, like a group project. Like when I always say, buyer's agent, you shouldn't contact the city yourself and then pass on to buyer. Well, the city told me that you can get a permit, or the city told me that there's sufficient water to build on this property. You should, in that situation, tell your client, if your client insists, then you can say, well, we could go to the city together to take a look at this. It's the same principle here. So refer your client to the public government source of information. Ask them to review it. You can do it nicely. And if they still persist, you can say, well, I'll come to your office, we'll take a look at it together. The other thing I think is important, what has come to mind to me and watching the news the past month, as a real estate attorney who most of his cases are keeping real estate agents out of trouble, is let's say that And no one really knows yet how these neighborhoods like the Palisades or Altadena will be rebuilt. Maybe individual property owners will have the resources themselves, with insurance assistance, with some governmental assistance to rebuild. But, you know, where you have hundreds or perhaps thousands of homes that have been destroyed, maybe you're going to see a developer, a builder, perhaps a corporate developer enter into the scene and say, well, I'm going to I want to buy all the lots in the Palisades, on these 5 streets, and I have a plan where I'm going to rebuild them. And I need a real estate agent to be my buyer's agent on the acquisition of all those properties. So on the buyer side, you have what one, institutional entity, a corporate entity is going to be buying them. On the seller side, you have individuals, you have families that own these properties. And I mean, it could be, a landmine in terms of how do real estate agents, what's their role here? So, we think, well, okay, I could be a buyer's agent for this developer, and we're gonna try to buy, we're gonna make offers on all 5 homes on this street in the Palisades or this street in Altadena. And so and this is all right now there's a moratorium. People can't do this. But let's say we're a year down the road, 2 years down the road, and there aren't government restrictions on unsolicited offers. So you're that acting as the real estate agent for that developer, making offers on a number of homes on a street to the individual seller. And okay, you can represent the buyer. Let's say you then want to become a dual agent for some of these individual property owners. I mean, we know, from when I've talked to you before, from talking with Peter, and other management in your office, that when you become a dual agent, you owe professional duties, fiduciary duties to both sides. It's permissible, it's fine, but it is a higher risk situation. And the principle there to keep in mind is a duty of loyalty and duty to disclosure to both sides. So you're the real estate agent, you're representing this developer who wants to buy up 15 homes in the Pacific Palisades, and you're thinking, this is amazing. I could make a ton of commission representing this developer on the purchase of all these homes. Wow. And you have an incentive there to really please this developer, this buyer. But if you're a dual agent, you also have a duty to get the best price for that guy, that lady who just owns the house there and wants the best price. So you have a duty on one side to get the highest price for your seller, but you have a duty on the other side to, drive a hard bargain. Your developer doesn't want to pay, top dollar for these properties. You have to keep in mind the duties to both sides. The way this really comes up, is the idea of, disclosure of any profit that you make from a transaction. So I've had a case where the buyer, who was a flipper, a developer, said to the agent, hey, if we close escrow here, I'm paying you an extra $2,000. And that's, not on the closing statement. I'm just going to pay you $2,000. Give me your bank account. I'm wiring it there if we close. Any profit that you make in a transaction has to be disclosed. That means on the settlement, on the closing statement, on the settlement statement. If you earn any penny on a transaction that's not on that closing statement, it has to be disclosed in writing to the folks that you represent. So, in that situation, well, first of all, I would tell this developer, hey, I'm really happy to represent you on buying all these properties, but I just want to earn commission. Unfortunately, I don't think I can accept the $2,000. If you do get into that situation where you're accepting any compensation outside of escrow, it has to be disclosed in writing to both sides. So you're sending that listing agreement over. You have to tell that seller that I want you to know that the buyer I represent is someone who I also represent on other transactions in your area. And they're also advised that they're willing to pay me another $2,000 if this escrow closes. I actually think the most important issue there is just this buyer on other transactions in the area. So you're sending the listing agreement or you're sending that TDS and SPQ to review to your seller, send out the email. Hi, here's the TDS and SPQ. Please complete them and return to me. I also want you to know that I represent this buyer on other transactions in your neighborhood. So it's in writing. If you just tell your client this over the phone, chances are, if a dispute arises, they're going to say, "I didn't know about this," and so having it in writing is important. The other issue I'm thinking about with the fire situation, a little bit simpler, is your forms that are used. And I've got here on my desk my TDS and SPQ. You all know these well. But is there anything that stands out to me if I'm representing, if I'm a listing agent on a property that has been impacted by fires? And I mean impacted like uh, it wasn't burned down, but it was near an area that was burned down, and you had smoke come into the house, and the house smelled like smoke. There was even some staining on the walls. So you had to move out for a week. You had a remediation company come in with the fans, and then you had um, a painter come in, repaint the house. Thank God the house didn't burn down, but there was some impact on it. And now that house is being sold. Do we do anything different with these forms? Well, my first governing principle to you, like I always say, is the seller's job to fill out these forms, not yours. But you are the real estate agent for the seller. So the seller is filling them out. Great. I like that. Then the seller sends you that text. Hey, when we had the smoke damage, uh, we got some money from our insurance company. Do I need to disclose that on here? So you need to answer that question to your client. And so, well, okay, my seller property questionnaire, section D as in dogs, is disaster relief insurance or civil settlement. Yeah, it asks. Are you seller aware of financial relief or assistance, insurance or settlement sought or received from any federal, state, local, or private agency, insurer, or private party? So there was the fire, your homeowner had their homeowner's insurance policy, State Farm, AAA, USAA. It wasn't a big deal. There was some smoke in the house. They got only $11,000 to help out with the cleanup, with the painting, but that's the insurance money that they receive. So to make a proper disclosure, seller has to answer yes to question D, disaster relief insurance or civil settlement. Um, okay, my SPQ here. And you're not filling it out because you're not the property owner, but you're getting a question from your client. Um, the city has, okay, so the house wasn't destroyed, thank God. The seller kept living on it. Down the road, they decide to move out. The city has imposed restrictions on new building in the area because they don't want it to be more dense because of fires. Evacuation was a mess in the Palisades fire. The city has imposed new restrictions on water use in this neighborhood out of concerns over water and fires. So TDS section L, governmental. There's 8 questions there. Number 3, existing or contemplated building or use or moratorium that could apply to affect the property. Yeah, if your seller has told you, I got a notice from the city that there's new regulations about water, that should be checked yes, and then the notation below. Number 6, existing or proposed government requirements affecting the property, that tall or other vegetation be cleared. That's my house. I have the yard, and then there's a hillside near it. And on the hillside, it's just open brush. And when I bought the house, I asked the title company, so is that part of my property that I own? They say yes. So, by May 1st of each year, I have to clear the brush. It's not a big deal. It doesn't cost that much, but it is a government requirement affecting the property. So let's say I sell my house and it turns out that there's mold in the house and the buyer is pretty upset about that. Then they also find out that there's a notice from the city for brush clearance. That's going to cost them $2,000 a year. Maybe that's the straw that breaks the camel's back, and they decide to sue over that when you add that onto the mold issue. So, is the seller aware of government requirements? That's another box that may have to be checked in light of some of these issues that have come up with the fires. So, and then moving into another topic here that I've talked about with Peter. So getting away from moving out of my comments on the fires and how that impacts real estate agents. And I hope that was helpful. I'll have some time for questions at the end into the other topic of leasing. And I talk about this because we have had some claims here recently in leasing situations where I'm not going to say tenant, it's a prospective tenant, someone applying to become a tenant becomes disgruntled or unhappy that they did not get the lease that they wanted. And they develop a claim that they were wrongfully denied the tenancy, discrimination. So that issue has come up recently, and it's been in the lease listing agent situation, like representing, the owner of a house or a duplex, and you're marketing the property. It's marketed online. You're representing a seller. I've got some tips on that. My first tip is in your paperwork, cross all your I's, dot all your T's. So you can show the property to the tenant. You don't have to submit an application to see it, but if they're coming back again, they're calling again for questions, and that's a good time to say the landlord wants you to submit an application for the tenancy. And then remember on that application, you can, request a recent bank statement. You can run a credit check. So get this, kind of objective, neutral information from the prospective tenant. So you're really evaluating their financial strength, not what they look like or where they're from. So if it turns out that the landlord decides that the landlord is not going to rent to that person, it is based on the tenant did not complete the application, or the tenant did not provide recent bank statements. Those are entirely objective, neutral criteria that are used to evaluate someone as a tenant. rather than other criteria that may be wrongful or that might generate a claim. The other tip I have on that is, and this is really also applies to sales transactions, is that the decision to buy or sell, or the decision to rent or not rent to a particular person is a decision of the property owner. It is a decision of the landlord. It is not a decision of the real estate agent. And you are a conduit of information between the tenant and the landlord. And so you provide the information received from the tenant to the landlord. You provide the application. You provide the reference to the land. You forward it. You forward the bank statements. Then it is the landlord's decision whether to accept or reject this tenant. So the prospective tenant that the landlord is renting to another person, your email should not say, "We're not renting to you," or "We don't like your application." Your email should say that the landlord has decided to rent to another tenant. Or the landlord has decided this. When you're asking for that bank statement and they won't give it, say, "The landlord requires a recent bank statement," not you. It's not, I need a recent bank statement. When this tenant is declined, again, it's not, "We're not renting to you," or, "I'm sorry, your application isn't accepted," is that the landlord has rented the property to another tenant. So you are the someone who provides information to the decision maker, but you are not the decision maker. Now, maybe that seems harsh on your landlord, but it's really not. All you're doing is communicating a decision in a business-like manner. But I think if, keeping those principles in mind, you're less likely to get claims by prospective tenants that they were, somehow improperly denied their tenancy at a property. So with that in mind, I'll go into my outline, the residential purchase agreement, the things I usually talk more about. But I'm happy to talk about the fire issues or the leasing issues also. But I'll get into the sales transaction issues, which for this seminar is the construction of the residential purchase agreement, the use of it really. And I have some materials on that I can put up on screen share. I think you have these already. You do. So you can follow along. Yeah, okay. So there we go. Okay, I've got my screen share up, and we all know that for the sale of a home in California, we use the California Association of Realtors residential purchase agreement. We had in one of my seminars last year, we had a great comment about, well, what if someone wants to use a purchase agreement that's not on the CAR form? And wow, that's a huge red flag right there. So, as a real estate agent at Coldwell Banker George, you should always be using a California Association of Realtors residential purchase agreement, the new one, the current one that was updated just about 3 years ago. And so if you are a listing agent, you receive an offer on a Microsoft Word document that someone presents to you. Hopefully a buyer represented by an agent isn't even going to try to do that, but you get maybe an agent or an unrepresented buyer just presents you a contract, just they have just typed out, somehow prepared, and it's not on a CAR form. That offer should not be accepted. You should send an email that says, unfortunately, my seller will not consider any offer that is not on a CAR residential purchase agreement. Oh, and remember, I just said my seller will not accept, not I will not accept. Remember, it's just like it's the landlord's decision to rent or not rent. It is the seller's decision. I mean, really, you're advising your seller. It is a decision you and the seller make together. When you're sending that email, just say the seller will not consider an offer that is not on the residential purchase agreement. Another quick tip here is, the contract for the sale of a home and the sale contract for the sale of a vacant land. There is a slightly different purchase agreement for vacant land transactions. And when you're sending that offer to your client, actually before you send that offer, one of the early conversations that you should have with your client representing them is, how do you like to receive documents? Do you want to receive documents in this transaction by email? Do you want to receive them by DocuSign? Do you want me to stop by your house and sit with you at the kitchen table to review documents? I mean, you can, take into consideration the sophistication level of your client. So, you're representing a 50-year-old attorney, or you're representing an 82-year-old retired person. Your 50-year-old attorney is fine receiving in DocuSign, but your 82-year-old retired person, grandma selling her house where she's lived for 43 years, probably best to not send those documents in DocuSign. So ask how your client wants to receive the documents. The new purchase agreement, paragraph 3, it's a summary or in a checklist format. The purchase agreement, of course, one of the most prominent aspects of it is what price are you offering? You're the buyer's agent. What's the price for the property? So when your client is making that offer, the offer should be based on a market analysis, meaning that you have shown your client comparables for the property. You've shown them, information online that this house down the street actually closed escrow for 1.5 million 3 months ago. This house 2 streets over, it has a different floor plan. It actually closed escrow for 1,450,000. So there's a basis for the offer. That can also apply if you're the seller's agent in terms of, well, what offer should I accept? So you always want to have, we use the buzzword comparables. What that means is, what are similar properties in the area selling for? The purchase agreement, of course, it calls for an initial deposit, an earnest money deposit. That's on the first page of the purchase agreement. You show, well, what is the EMD, the initial deposit? 3% is pretty common for that. I think that if you offer your 3%, but your seller comes back and says, no, I need 8%, I need 6%, even I need 5%. That's a red flag. I think that the seller asking for more than the typical 3% is a red flag that this is a transaction where you really need to be on your toes more. And maybe when that seller comes back and says, no, I need 7% as the deposit, that is your red flag to say, nope, we're stopping this transaction here. Your initial deposit. So, I mean, the common question is, if this transaction doesn't turn out the way I want it to, if I'm not happy after I get the disclosures, can I cancel? Yes, of course, if there's something in the disclosures that is troubling to you, you can cancel, but then can I get my deposit back? And the answer to that question is that if you're canceling within your rights under the purchase agreement, yes, you can get your deposit back. If the seller is somehow in breach of the purchase agreement, then possibly not. But the example I just mentioned of, well, when I get the disclosures and I see that, or even actually, so I do my home inspection, even a better example. I see there's cracks in throughout the house. I see that there's the notation from the home inspector, recommend that you consult an engineer on these cracks. Do you receive that inspection report? You see it yourself? Sure, that is a proper basis for cancellation. And in that situation, you have a right to the return of your deposit. You say your seller's a little bit difficult. There can be a negotiation process, a bit of a struggle to get your deposit back, but under the purchase agreement, you do have a right to have that deposit back. You're, in good faith exercising your cancellation rights under the contract. Your it can be something like the home inspection report, or I saw cracks in the garage when I visited the property. That seems obvious to me, but can it be something like more vague? Can it be like, well, I just changed my mind? I mean, my answer to that question is yes. So if you're within your contingency period and you just, and what does, change your mind mean? It means, you drove the neighborhood again, you walk through the house once more. You just don't have that like, that real like of the property that you thought you had on that first visit, or you found another property down the street that you like more. There's not something, definite you can point to an inspection report, but it doesn't need to be that definite. It can just be, I really decided I don't like this property. In that situation, you can kind of hang your hat on the investigation contingency. And you're, as a buyer's agent, you can just tell the listing agent, my sellers have decided not to proceed with this transaction. I mean, as the buyer's agent, you can keep it vague. You can just say they decide they really don't like the house and they're not going to proceed with the transaction. And that is a proper cancellation if you're still within your contingency period. And therefore, you have the right to have your deposit back. On my outline here, try to move through this quickly. And for loans, I stay in your lane. Just like I said, you should not be advising on, is the city going to expedite building permits in a neighborhood impacted by the fires. It's also not your role to advise on if a buyer qualifies for a loan or on what terms. That's for a loan broker. So I would bet you all have, on your phone, the name of a loan broker that you refer clients to. So just tell them, here's Susie, who is a loan broker. Here's her name and email address. Reach out to her. She'll help you with a loan. Okay, the next one on our outline here, just about, say making an offer, your buyer's agent. Don't exaggerate your buyer's financial abilities to the listing agent. Just convey what your buyer will offer. So the statement of, my buyer is a top doctor at UCLA and makes $800,000 a year. It's okay to say my buyer. I would say that differently if I was the buyer's agent. I would say, yeah, my buyer is a top doctor at UCLA. She does really well. If you're making specific statements about income, that also implicates your duty. You're a fiduciary. So as a fiduciary, you have a duty of loyalty and a duty of confidentiality. So if, your client has said to you, yeah, tell them what I earn each year, then you could say that. But Other than that, I wouldn't say, how much your client makes each year, and you shouldn't really have to. Really, what happens here, as you know, is a lot of the times as a buyer, you'll provide a proof of funds. That's even more powerful than saying my buyer's a doctor who earns $800,000 a year. So you provide a proof of funds. What is that? Get a recent bank statement with your buyer's name and address on it that shows what's in the account. I had a case, it was a case in Pasadena, where the seller argued that they were misled by the proof of funds because the proof of funds was, you can look up your bank account on your phone, take a screenshot. The proof of funds was a screenshot of the online account. It didn't show the name. So that's why the bank statement being more formal is the better way of doing it. A contract requires performance unless it's contingent, and residential purchase agreements have contingencies. So your loan contingency, your buyer needs to get a loan. Your appraisal contingency, your investigation contingency. My question on these is, what's the best time period for the contingencies? How short can you make them? As the buyer's agent, it's a competitive marketplace. You probably have, a desire to shorten the contingencies. My buyer can have everything together in 7 days. That's all they need for this investigation contingency. That's a really attractive offer to a seller. There may be some situations where we have a very sophisticated buyer who can do that, like a developer, but I think that in most of your, mom and pop and regular folks who are buying their first home, 7 days for the contingency is not wise. Go for 10 days. Give your client some more flexibility on getting that inspection scheduled, doing the inspection, then reviewing the report. Contingency removals. My message for you here is that a contingency has to be removed by using the form. A conversation, a text, or an email does not remove a contingency. And cancellation. Well, why would a seller want to cancel? Well, on the seller side, the buyer doesn't put that EMD in that initial deposit into escrow in 3 days. That's a big red flag right there. Buyer doesn't remove a loan contingency and investigation contingency. So they don't remove a loan contingency. Can you serve a notice of cancellation the next day? No. The residential purchase agreement requires you to go through a previous step, giving a notice to buyer to perform. Buyer side, maybe your seller doesn't give the disclosures properly, or maybe it's that situation that I just mentioned. Your buyer just doesn't like the property anymore. So under paragraph 14D of the purchase agreement, there's a broad right to cancel. So if a buyer sees something they don't like, or they just don't like the property anymore, they can cancel the contract. If, however, it's a situation like the seller isn't giving access for inspections, or if disclosures aren't delivered, then you have to do a notice to perform. Cancellation, remember again, there's a cancellation form that is used. Part of the form is for cancellation of the contract. Part of the form is for cancellation of escrow. And actually, I should say first, before that, the contract is between the parties. The escrow is separate. So if you give a notice of cancellation of the contract, does that automatically cancel your escrow? No, there has to be an instruction separate to the escrow holder to cancel the escrow. Why is that practically speaking important? Because just canceling your contract will not authorize escrow to return your initial deposit. So your buyer's got $40,000 sitting in escrow and they want it back. Escrow needs an instruction in writing from both sides for the return of it. Okay, and just some final thoughts here, and then I'll stop and take questions. Another thing that I've seen come up in some cases is I'm buying this house. What's really part of the house? It has that big den, we call it the movie room in the ceiling. It has this projector. It has the devices connected to it for the home movie theater. But when buyer moves in a week after close of escrow, that's been pulled out of the ceiling. It's like, what? That's why I paid $1.6 million for this house because I love the movie room. Is that Was that part of the agreement for sale? Well, paragraph 9 says all all existing fixtures and fittings that are attached to the property. That movie projector, it's the projector and the wires are screwed into the ceiling. So that's attached to the property. I thought I was buying that. Under paragraph 9, it's attached to the property. It would appear then that it's part of the sale, but my tip there is that check boxes in paragraph 3P. There's space where you can check a box to say something's included. And there's also places where you can write in. So if you want to see it when you're taking possession, when you're moving in, put it in paragraph 3P. And also do a verification of property condition. Do that 2 or 3 days before, 3 days, I would say, at least 3 days before closing to see if the property is still in the condition that it was at the time that the offer was accepted. And my last point on this is I just did a settlement agreement yesterday for a case where buyers bought their first house. They came to move in, they were moving in, and then some guy shows up who says, he says, "Whoa, this is my house. I live here." We're like, "What are you talking about? We just bought it from Christina." But there's Alejandro. He shows up and he's saying, "I live here." It turned out that the seller had a tenant in the property that the buyer and the buyer's agent wasn't aware of. The seller did not check the box on the SBQ. There's a box for, title and leases on the property. Seller didn't check that. So when you're doing that, when you're walking through the house and at the verification of the final walkthrough verification of condition, if you see something that looks like it's not just Christina and John who were the sellers that lived there, there's another room, there's another bed in there, some other photos, and that room has its own separate entrance. I would ask the listing agent, does your seller have a tenant here? So with that, we can have some discussion and answer questions you may have. Anyone have any questions?
Brian, I have a question. Regarding the discrimination claims, the Civil Rights Department is pretty, I think, and nowadays they are pretty sensitive on those issues. So when they have complaint, they have the duty to investigate, right?
Yeah, that's right. And that's what yes, that was what I was thinking of when I was talking about the leasing issues. So the prospective tenants have filed some complaints with the California Civil Rights Department. And the Civil Rights Department, they take those very seriously. They're a government agency.
Mhm.
They will investigate them, and it could result in a lawsuit. So it's important to pay attention to these issues.
So what's the protocol of the complaint? In other words, they lodge a complaint with the Civil Rights Department, and the Civil Rights Department does the investigation, and then they decide whether the plaintiff has a reason to sue in a civil right lawsuit or what?
So in that case, if it's not in that situation, if it's not resolved through the Civil Rights Department, the plaintiff can sue, in court. The Civil Rights Department, it's not really the court system, but sure, the Civil Rights Department will investigate it. They'll ask us to go to mediation. If it's not resolved after mediation, the tenant, they can file a lawsuit. So for the agents on this issue, of course, when learn of a claim, if it's a civil rights complaint, any kind of claim against you, please let Peter know as soon as possible. Immediately, I'll say that. Yeah.
Yeah. And today, the Civil Rights Department today have the training class for to avoid discrimination cases.
I'm not sure if they do have a training class themselves, Peter, to be honest, but I can look that up and send an email to you with that information. I mean, I would suspect they don't have a training class, but I'll check that out.
Okay, thank you. Any questions for Brian from the agent?
I have a question.
Jimmy.
Where and how do we disclose extra pay outside escrow commission?
Jimmy, do you have a question? Oh,
So the question was, I'll just repeat to be sure I understood. So if you're getting a payment from a buyer, from anyone, from a seller or a buyer outside of escrow, okay, so first, yeah, that can become a problem. I would really like for the payment that you receive to be the commission, which is set forth on the closing statement. But if there's a payment that is received or going to be received by you from a buyer, perhaps from a flipper, separate from escrow, put that in an email to your client. And again, so this would be a situation where you're a dual agent. So buyer is giving you, an incentive to close this deal, and it is a payment outside of escrow. It's $1,000, it's a $2,000, or maybe it's $3,000. And by outside of escrow, I mean it's not on the closing statement. In that situation, I would put that in an email to the seller.
Brian, this is Oscar. I have a question. If a friend refers you to a buyer or a seller, and he tells you, look, after you close escrow, just give me so much money for your check. Can you get in trouble for that? I mean, if they want cash, but it's for your own money?
So if someone refers you, someone
And
tells
they
you,
want
hey,
some,
I have a friend who's looking to buy a house, you should talk to them.
yeah, and then he says, okay, after you close escrow, give me some money from your commission, but I want cash.
So if you're paying that person out of your commission, I mean, in that situation, I mean, it's like a loss to you. So I don't think that's the same as the situation I was just talking about, because that person's not it's essentially a financial loss to you, not an incentive. And two, that person's not a party to the escrow. So I don't see that as a situation where that needs to be disclosed to your seller or buyer.
Uh, okay,
Brian,
thank you.
that's the thing. Our referral fees, I guess he's kind of referring to a referral fee. Is that still legal?
So a referral fee by you uh to someone who refers to you.
Yes.
Okay. On that one,
Yeah, yeah, like a referral fee, but from your own money, from your own commission, but they want cash.
I want to look up the DRE rule on that one, but it's not the same as the other situation I was talking about. Let me see.
Okay.
Yeah. If you give me your email address, I can email you the answer on that one.
Okay, I'll go ahead and put it in the
Yeah,
comments.
put it in the chat.
Okay, I'm gonna put my there too. Right.
Okay. Let's see.
Any more questions for Brian?
I have one question.
Sure.
If the offer come in as a full price offer or even the over asking price offer, can the seller still say no to that or reject that offer?
If it's over asking price, that
Or the asking price or even over asking price, can the seller still say no to that or reject the
I
offer?
mean, the seller is not ever required to accept an offer. So, I mean, yes, the seller can reject that offer. And, maybe the seller wants to reject it because they don't like the contingency period or they, have some other reason like the length of escrow. So, I mean,
Okay.
the price is important, but there are other things a seller consider. Like maybe your seller wants a 30-day escrow and then a 15-day lease after closing. But that buyer won't give that. They're willing to pay a top price, but they don't like that term of the purchase agreement. So there is not so if you get an offer, at the listing price, that does not bind the seller to accept it.
Okay, thank you.
Okay. Picture of these emails, and then I'm going to check on that issue that you asked me about with referral fees.
Okay.
Anything else? Questions?
No, we are in good timing. It's 11:01 right now, so good. Very good. Any more questions for Brian? If not, I would like to thank Brian to come in to talk to us. It's very informative and very educational. So, and if you have any question at all, you're always welcome to call him, email him, or you can ask me to contact him. Okay. So with that, I would like to adjourn the meeting and thank you all for coming.
Good to see you all. Thank you
Thank
so
you.
much
Thank you,
for your
everybody.
time.
Thank you.
Thank you. Bye-bye, everybody.
Thank you,
Bye.
Brian.
Good to see you all. Good luck with your transactions.
Thank you.
Thank you.
Thank you.
Bye-bye.